I'm Jane Fielding and I'm head of the Employment, Labour and Equalities team here at Gowling in the UK. And I'm delighted to welcome you to the third in our series of 4 webinars, which we're running last week and this week to replace our usual in-person mid-year review. So the topic for today is managing tricky ER cases in a COVID-19 context. And just to run through the agenda with you of what we're going to cover, we picked this because it's always a useful thing to remind yourself of how to approach these sorts of tricky employee relations issues and a review of the basics. So that's the first part of the session. The next 2 topics are practical issues essentially that arise because of the nature of the coronavirus pandemic. So how do you deal with an ER issue when the people involved, the people you need to speak to, are furloughed? And that leads on to issues around if you can't meet safely in a COVID compliant way in person, you're going to have virtual hearings, and how do you deal with those and approach them? And then the last 2 topics in the session are focusing on the sorts of issues that we're seeing coming up in this current pandemic environment. So we've got health and safety issues around people's return to work concerns, for example. Those give rise to whistleblowing issues potentially, and there may be other issues around whistleblowing that we need to look at. And then finally, there are naturally issues around ill health, but also potentially issues around managing people with longer term ill health issues or disability issues in this current environment. So the aim is to refresh on basic ER, but also to look at these issues very much in the coronavirus context. And our speaker today is Simon Stephen, who is one of the legal directors in our team. And he's extremely well placed, possibly uniquely well placed to talk about this topic, because as well as having worked with us as a lawyer for nearly 15 years, he's also spent 4 years in an employee relations role in a major investment bank. So he's seen things from both sides, if you like. So he's our speaker today. He's going to speak for about 30 minutes, and then we'll have time for some questions. So a couple of housekeeping points before I hand over to Simon. If you would like to ask a question, then we're using the Q&A function, which you'll find in the bottom of your screen. So just click on that and type in your question. We'll do our best to deal with as many as possible at the end before we close, but I can't guarantee that we'll get to all of them based on past numbers of questions that we've had. And secondly, at the end of the webinar, you will get a questionnaire which asks for feedback on the session. Please do take a couple of minutes if you can to fill that in and send it back to us. We do read your feedback and use it to shape future sessions. So we'd be really grateful if you could do that for us, and I'll remind you again at the end. So I will now hand over to Simon.
Thank you, Jane, and good morning, everyone. Welcome from my kitchen. So as Jane said, I'm pretty well experienced in ER, so I'll be running through the agenda that she put forward. The first point on the agenda, if I can make my IT work, is a run through of the general principles. I appreciate that for a significant number of the people on the call, ER is your bread and butter and you are very experienced. So this is in no means an attempt to teach you to suck eggs. I think it is always important in an ER case to remind ourselves of the general principles in any case, but in terms of COVID and the COVID context, as I'm calling it today, I think it's even more important. Life is generally different, of course, and in many ways more difficult. So ensuring that we think back and fall back on the general principles are going to hold us in good stead for running an ER process and mitigating any risks or fallout at the end of it. So we have the general principles as I see them on this slide there. There's 5 of them there. The first point I'll make or wouldn't make though is that any ER case, it is in fact the employer's process. It is always your process, whether that's a disciplinary, an investigation, a grievance, or performance management appeal, whatever it might be. It is your process to be done in lines with how you want to do it. It's always important to keep that in mind, particularly kind of I think kind of now when there are going to be more tricky issues. That said, you must always remember that all steps are to be reasonable. Reasonable is a wonderful word which lawyers spend ages arguing about in all types of context. I think what it means really in ER cases is that somebody looking from the outside will go, okay, that's fair enough. Yep, I can see why they're doing that. That's kind of fair to go with. So I think it's always kind of looking at it from that point of view. And it's also important that all the steps are reasonable. So that's everything from who we choose to hear a case, who we choose to do an investigation, through to how we do each step, how we communicate it, and how we come to a decision. The second point is that processes must be timely. I think this is something we're all alive to, and indeed lawyers love to remind clients that things must be done quicker and kind of maybe put a bit of pressure on. From sitting on the other side of the fence, from running ER cases, I completely now understand why that can be really difficult to do. You're reliant on so many different moving parts within a business, of which an ER process is just one. But that said, we must always make sure that the processes are timely. And I think in a COVID context, this is one of the issues that is going to be more difficult because there is just simply so much else going on within a business, within personal lives. But it's, and again, this runs through the whole life cycle of an ER case right from the outset. And I think in a COVID context, probably the most important thing about the timely point is to make sure that when something comes up, it is dealt with there and then, or at least the initial steps are taken there and then, kind of putting a flag in the ground so it doesn't drift. The next step is the process must be fair. Again, another wonderful word which lawyers can argue about, but it's really meaning that it's balanced in the interest of everyone to the extent it can. No one likes an ER process apart from maybe a number of you on the call and myself. I think they're brilliant. I love doing them. But no one likes being disciplined. No one likes being investigated. People don't really like raising grievances because by the time you've got to that, you kind of dug your trench and crossed the Rubicon. So having that process is fair, is balancing that with everyone. And then consistency. I think consistency, along with timely, is going to be one of the difficult things in a COVID context because things are different nowadays. But it is really important to bear in mind that whatever we do in an ER case, there are going to be other examples before COVID and after COVID. And to the extent we can, processes, the decisions made, the outcomes, how we do things are to be kind of consistent and throughout. And a good example was in the news last week about a postman who was dismissed. He was videoed urinating in public because he wasn't able to get to the nearest public toilet in the supermarket, I think it was. And he was dismissed, and you might think that's fair enough. That's pretty gross, really. But he was successful in his unfair dismissal claim because he brought a lot of evidence to show that a lot of other police, a lot of other postmen and women had been caught urinating in public, and they hadn't been dismissed. So the tribunal said, well, that just shows that there is an inconsistent approach and the dismissal is unfair. So it's very important to bear that in mind. Then, as usual, there's a catch-all, taking into account all the circumstances. This is all the circumstances of the individual, and that will include the COVID context, because all the business, who's doing it, so everything else. So if you bear those 5 points in mind, together with the fact it's your process, that's going to give you a good kind of backdrop through conducting any ER process. So in terms of back to basics, again, not teaching you to suck eggs, but a reminder of where these basics come from. First, we have the ACAS code of practicing and the code of practices and the guidance. And I'll put a link there on the slides. And I think the slides are available afterwards, so you'll be able to access that. It's a very short document. You may not have read it for a while. Always good to go back and read. So make sure you remind yourself about what it says. And also it's important to make sure you are up to date with what your internal policies say and kind of how they apply to the ER case you are dealing with. And then I think a new back to basic that comes up in the COVID context is the importance of risk assessments. Risk assessments are something that always been advised on from a health and safety perspective, but frankly, probably something we've never really been too involved in. Now risk assessments are at the forefront. Risk assessments are such a key thing in kind of managing where we are now. It's a good reminder that I need to do one this afternoon, which Jane would please to hear me say. But it's very important that you take into account the outcome and input of any risk assessment, including in any ER case. They will feed in, and it's quite an easy win or an easy argument for someone who's challenging an ER process to say this is not in accordance with the risk assessment. So I think bearing that in mind and feeding that in is very important. But before we go any further, big red stop sign, and that's not just to add some colour into my otherwise slightly dull slides, but it's really important when faced with any ER issue As I said, you're acting timely, it comes up, you picked it up, you put the flag in the ground, but it's very important to take that step back and just stop and think, do we need to do this? Is this something that needs a formal process, or is there other better ways of doing it? Now, this is always something that should be in consideration, but I think in the COVID context, given all the other complexities we have in running a business, in people's personal lives, that it's important to take this step. As an example, I had talking to a client a couple of weeks back where there was a pretty flagrant data breach, and it would look pretty kind of straightforward in terms of, well, that is an issue that needs to go through to disciplinary. We just kind of counselled a bit of caution, knowing a bit of the background about the people involved. And before launching into the formal process, which is what the client wanted to do, they had a quick conversation, and it turns out the individual just made a mistake because they were struggling with childcare, struggling with mental health, struggling with a number of different issues. So that the risk was able to be mitigated, and that process was able to be done through a different means. Had they gone through the formal process, things could have escalated very quickly into something that it didn't need to be. So just a word of caution, just to always stop, think before any formal action is taken. So flipping back to the ACAS Code of Practices, the key importance, I guess, from a legal point of view, that the Code of Practice still applies during during COVID, and any failure to comply risks an uplift in compensation for about 20 up to 25%. It's also a very easy win, or a very easy argument for someone who wants to challenge what you're doing, to raise it and say what you are doing is not in accordance with the Code of Practice. It gives you something else to think about, and it kind of detracts from moving on with the process. Because ultimately what we want to do in an ER case is start it and finishing it as quickly as possible. And the things that delay, obviously ill health and things like that, will come up, but it's arguments and challenges from employees. As I said before, nobody likes being in a process, but to the extent you can engender some form of trust to enable the process to go from start to finish, the better. And making sure that there are no easy wins in terms of the Code of Practice, or not complying with the guide, which link is there as well on the slide, and indeed the updated COVID-19 advice from ACAS are all going to be key points. Drawing out the specifics that I think are, you may not have seen, or kind of are important to draw out right now about COVID and the context, these are the ACAS key points that they've got in their specific COVID advice. So, over and above the Code of Practice and the guidance. And again, you look at them and you think, okay, that seems kind of self-explanatory, it's quite obvious, but they're very easy things to kind of lose track of during the sight of an ER case. And they do link up with those key principles we're talking about at the beginning. So first of all, following the public health guidelines, making sure that your interpretation of them through the risk assessments and how you do that, you are kind of still complying with them through an ER case. Of course, considering the health and well-being of employees, which are going to be particularly or potentially more of an issue now during COVID. And then we come to the consider and discuss options. That's the stop sign. What are the options? Do you need to do it? Are there other means of doing it? And then also another key point about communicating and explaining decisions. This goes on to the kind of that trust point. To the extent you can get trust in an ER case, telling people what you're doing and why is going to be really key to preventing the challenges and enabling you to carry on with the process. Even if they are decisions that people don't like, if you can communicate and explain how you've done that, why you're doing it, coming back to those key points, why it's reasonable, why it's fair, that's going to go a long way to helping you complete the process, get it done. And it's also fast forward into the future. If there are any tribunal claims or litigation, then it's going to give you good stead in defending those. So the next kind of back to basics point is quickly on internal policies and processes. They're obviously very important in how you govern ER processes, and there are so many different types. You may have quite a high level process, or you might have an all singing, all dancing process. It's very important before you start doing any ER processes. Indeed, I'd recommend you can do it as a matter of course, even if you don't have any ER cases right now, is to ensure that they fit the current scenario. Do they allow you to do what you need to do to manage a case during COVID? For example, virtual hearings, which we'll come on to shortly. And if you do need to flex or adapt any policies, if they don't fit it, then plan what you're going to do, plan how they feed into all ER cases, and then communicate those changes, make sure they're clear in any processes so people understand why things are being slightly differently. And again, that then removes you away from the potential risk of having a lawyer or a representative or someone coming in and saying, oh, you didn't do this and your policy says you should have done. So kind of building into that plan and communicating them. And also then just making sure that any changes, any flexes to policies are consistent throughout. So if for one case you make a flex or you adapt your policy to accommodate a situation, be prepared to be consistent with that going forward, because these are the kind of the pitfalls that are very easy to fall into. So that was a quick run through from the back to basics. Again, I appreciate the kind of, there's a number of experienced people on the call, but they're very important to bear in mind and keep bearing in mind all the way through. So moving on to some more of the sticky issues with ER cases, which we'll no doubt encounter. First of all is the COVID job retention scheme and furlough. Furlough is something that I think the government has found that people are using a lot more than they were expecting, and there are significant numbers of people on furlough. The difficulty in an ER context is that rule that I'm sure we're all familiar of, is that someone on furlough leave cannot do any work. They cannot do anything which adds values or does services for an employer. So that raises an immediate question, which is, if I have an ER case, if I discover a disciplinary issue, or indeed somebody while on furlough is doing something they shouldn't do, or somebody raises a grievance, what can I do? Can I actually do the process? And the quick answer is yes, you can. The long answer is, but that depends on a number of different points. The first, and this is why it's important, I think, fall back onto the basics. ACAS are good advice on this. Now, ACAS advice is not a statement of law. It's not like the code of practice, which can be taken into account and can affect compensation. It is advice. It's advice to be taken in kind of in consideration in how you run your processes, your business, as part of everything else. But it's a very important kind of backdrop. And the ACAS advice is clear that an individual who is on furlough can take part in the ER process. They can take part as a subject, as an interviewee, the chair, a witness, or indeed as a companion. But, there's always a big but, they can only do so if they're doing so voluntarily and in line with government guidance. So pausing there, in line with government guidance, that will fall back into risk assessments. How are we interpreting government guidance and all our requirements? But also then it's the, in line with government, doing it voluntarily. So it's that engagement, that communication with people. And there has been a recent case which has held that given evidence in court, so in being a witness in a court case, is not work for CJRS purposes, say for furlough. And I think that's a useful kind of analogy, but it's not quite the same as somebody who is actually kind of involved potentially as part of their day job. But I think the reality is that it's a balancing act. It comes back to what is fair and what is reasonable, and in how do you do something timely. If somebody is on furlough and you take the view that you can't deal with that, then you're not going to be able to do a timely investigation. So are you going to be able to explain and justify that delay to that individual concerned, to any rep that they may have, or indeed to a tribunal? So you've always got to balance that against what is the risk. And there is the risk, of course, that an individual who is on furlough and you take part, they object, or they complain that you're making them work, or HMRC might get more interested. So it's always that balance, and it comes back to that stop sign. Do we need to do this now? In most of the cases, given the fact that we need to do things timely, the answer will be, yes, we do need to do something now. And I think the approach to take from this is taking into account all the individual circumstances. You can proceed by ER cases with people on furlough, as long as you engage with them and they're not doing it against their will. So moving on then to the next bit, virtual processes. So you've kind of got an issue, you've run through your basics, you've checked people are on furlough, you've taken a decision that actually people on furlough, you are going to approach them. We are going to move this on timely. How are we going to do it? Some offices, workplaces obviously have people back in the office now. We'll come on to kind of those meetings in person, but a significant number of people are still working from home, or indeed in furlough, they're not working at all. So how are you going to manage your process through that? Virtual processes are something which are pretty common and now going to be looked at. Indeed, the tribunals themselves are using virtual hearings. So the tribunal are moving into the future world, then there'll be an expectation that everyone else will do as well. The first thing about virtual processes, I think I'd say, is they're not really a new thing. from my experience working in a global company, is that virtual processes were done quite often because you can't realistically fly people from New York, or to be a witness in an investigation, or you can't fly people from Spain for a disciplinary. So they do work, and they can and they do work. Before you do anything, of course, though, then you fall back into the risk assessment. If an individual is working from home, does the risk assessment, and they might have mental health concerns, etc. Does the risk assessment throw up anything that else needs to be taken into account? And again, you come back to the fact that, do your policies allow them? I think it's very unlikely that there are policies which won't allow them, but it's always important to check that you haven't got something in your policy which prevents you from doing it. Particularly maybe in kind of larger organisations or regulated organisations or public bodies, where the processes are kind of a bit more set in stone and actually kind of set out more verbatim about what will happen. So you've got to make sure you can do them. Before you embark on any virtual process, it's really important to make sure you've done that planning. That's kind of key points. Planning how it's going to work and communicating how it's worked to people, because many people will be unsure about it. It is frankly quite odd doing things by video all the time. You said doing a webinar by video and having done tribunal claims, it is different and it can be quite unsettling. So making sure it's all communicated, having that clear process, what's going to happen, what to do if technology fails, how do we deal with confidentiality, how do you make sure no one else is sat in the room with them. All these things need to be built out in the plan to start off with. And then just a few kind of practical points on it. You need to ensure that people have access to secure technology. You need to be able to accommodate a companion and a representative, something that's often forgotten. And given the context of COVID, can you flex using a companion representative? Of course, the right is to have a colleague or a trade union rep. In some situations, that might be quite difficult for people. They might not want to have a companion on another screen on a video call. They might be working at home with a wife, parent, partner, husband, whoever it might be, and it might be easier for them to have them sitting in with them, because frankly, they're going to be in the room anyway. Normally, you'd say no to these in the process, but can you flex to accommodate these? And of course, then you document that decision, document why you flex that, so you don't get into trouble when you don't allow someone in a non-COVID context in a year's time. That consistency piece. And I would just say there is only going to be very rare circumstances where it's right to flex to allow lawyers in. To be frank, lawyers in ER cases just tend to get in the way and turn things into processes that they're not. And then just kind of running through these other key points, how are you going to approach documentation? Obviously, sending e-bundles through PDFs, etc., is much preferable, but can people access them? Are they password protected? Are you using the kind of same software to transfer? All these things need to kind of be planned and built in from the outset, so they don't become something for people to get upset about kind of at the time, the day before a hearing. And again, communicating with individuals and accommodating their circumstances. Do they have access to a private area? They might be kind of in a small area with lots of people also working there. And do they have health issues that need to be taken into account? That's where the risk assessment comes in. Mental health is and will continue to be a big issue for people working from home. Does anything like that need to be taken into account in how the virtual processes work? And not least because they are much more tiring. So if you're going to have a full day disciplinary or a 3, 4, 5 hour investigation meeting, think about how you're going to structure that in a virtual hearing, because it's going to be much more tiring for all those involved, not just the individual, but the chair and any companion as well. So touching on meetings in person, I just think, do you really need to do them in person? It obviously adds more risk. And you'll link back into the risk assessment. But there's a number of practicalities to meet, even if you are an organisation where people are back in the office. You'll have to kind of think very carefully about how you do that, where to meet, how can you keep socially distanced in an investigation room, how can you accommodate breakout rooms and companions if they want to go and kind of have a discussion, do you have enough rooms that are sufficiently kind of secure and safe? And again, the approach to documentation. How are you going to get people documents? How are they going to be safe and ensure that those documents are clean? And indeed in the meeting, when you're in the meeting, often documents will pass between people. Are you going to allow that? How are you going to communicate? All these kind of little things which will come up as issues in a hearing should be planned out in advance. So moving on to the next kind of sticky issue about ill health and disability. This is always a tricky issue in ER cases. And I think it's more tricky in the COVID context. But as a recap, as with all processes, you're going to have to build in reasonable adjustments and also claims under Section 15 of the Equality Act, which is the claim where something happens to someone and it's arising in consequence of a disability. And the prime example for that is you discipline someone for absence and their absence is because they're disabled. So you're not directly discriminating against them, but you are doing something to them that is basically kind of in consequence of a disability. So these are things that are going to be built out even more. They're going to come more to the fore, I think, during COVID, not least because health concerns are going to be at the forefront of everyone's minds. It's going to be, as I said, it's going to be built in with the risk assessment. But as with virtual hearings, you're going to have to consider the impact of logistics on people. How is this going to impact on someone who is unwell or who has a disability? I think the reality is, as I said before, it is going to be more stressful. So do we need to think about whether that will exacerbate the conditions and kind of make further adjustments to that? And I think a wider point, which can easily get forgotten, is that if people are working from home, or indeed if people are coming into the office and having these meetings, they may well be accommodating dependents or associates back home who have medical conditions, which could be something that is impacted by something that happens to that individual, particularly if, say, commuting through public transport. So all of those things will need to be borne in mind and again, communicated and documented. So it's that communication with the employee, making sure that you understand what that employee's kind of needs are and communicating with the employee about why you are doing various things. And more importantly than ever is you making use of all the medical support available, whether that's any employment assistance programs or occupational health. I think it's a matter of course, if somebody is off sick or somebody is unwell, the advice is always to get occupational health advice. Do you need to do that in advance, kind of more at an earlier stage than you might otherwise do? And you're going to have to prepare to be more flexible because there will be more ill health issues. People will be more stressed. Mental health considerations are going to be most likely, I think. So you are going to face these. And you may well end up with that situation where people are in fact off sick with stress. I think if you can build things up right at the outset to try and make it as easy as possible, bearing in mind all the things we've talked about, that should mitigate the risk of that happening, particularly if we are more compassionate. Now, that probably might sound a bit weird for you to hear a lawyer saying we're going to be more compassionate, but certainly from my experience of doing the in-house, is that compassionate understanding, acknowledging people's problems and working around them with communications and plans helps to engender that trust and helps you kind of get that process kind of going through. So again, there's no real kind of magic wand with the ill health and disability in the COVID context. Other than that, it's just something that is going to need more consideration than before and at an earlier stage than that before. So health and safety issues are also going to be a potentially sticky issue. And again, sounding like a broken drum, the importance of the risk assessment. Always come back to that risk assessment, your internal policies, and those kind of principles we covered at the beginning. People will have concerns about returning to work. They might have concerns about their own health and safety, and they might have concerns about the health and safety of dependents and colleagues. So you will get complaints about that, but also when you're asking people to come into the office for meetings in person, this is the kind of issues that you'll have. People will also have concerns about participating in processes. So you'll have the two situations. People say, I am raising a concern about what is happening to me, and that is my grievance, or that is my kind of whistleblowing complaint that I want you to investigate. But also there's going to be an issue about somebody who is in an ER process who raise concerns during that process about what is happening is in fact a breach of their health and safety, particularly working from home, mental health, all these kind of things. So all of this needs to be taken into account and planned at the outset, falling back on the risk assessment. And it's really important to remember that key thing about health and safety issues is that employees are protected where they reasonably believe there is a serious and imminent risk for health and safety. So if somebody does believe that and they don't come into work, or they say they won't participate in an act, then they are protected from detriment and dismissal. And I'll just pause kind of on the detail of that because that does link a little bit in with the next thing, which is whistleblowing. And I think the expectation is that there will be a high number of whistleblowing cases come through. Charities such as Protect reported a significant increase in calls to their helplines. I had a call with the chief exec, of Protect a couple of weeks back, and I think the number she was quoting was about 50% increase. And this is people complaining about furlough fraud or misuse. I'm on furlough, I'm being asked to work. Or indeed, we've had ones where people are saying, I'm not on furlough and I should be, trying to do that as whistleblowing, which is interesting. But people also raising the health and safety concerns through the whistleblowing format. And people then also, similar to the health and safety, in the fact people raising health and safety concerns about being asked or how they participate in the ER process, there's possible retaliation for having raised concerns in the first place. Or, they could be concerns raised through a disciplinary process. So I think that being asked to do this investigation is impacting on my health and safety, or indeed of others. I've raised this concern, but you're not dealing with it, or I don't think you've dealt with it properly. You can then potentially face retaliation claims for having raised those concerns in the first place. And the reality is that any whistleblowing around furlough fraud and misuse or health and safety concerns are likely to be seen as likely to qualify as protected disclosures, which gives people further protection from being subjected to a detriment or dismissal, as in the health and safety claims. So a different stop sign, just to hopefully kind of keep you awake. But then when dealing with whistleblowing cases and any health and safety, so if you've got any tricky ER issue, and I think this the same as for ill health and disability, when you have these issues, stop and take a pause. I don't mean stop the process. I mean just stop and think about how this impacts. Do not let the knee jerk. That is one of the biggest pitfalls in tricky ER cases involving ill health, disability, health and safety and whistleblowing, is that people's immediate reaction. Somebody says they are feeling stressed and the reaction is, well, we're all stressed. I don't believe you, let's just crack on. That knee-jerk reaction, you are bound by it and it will come back and bite you later on. Tribunal claims have been listed for years in advance now. We've had ones where there's 18, 24 months. But the individual's not going to forget what that initial reaction was. And you're still going to face those issues in explaining it to a tribunal. And when you do this pause, just make sure you pause and understand what is being said. Something may not be being phrased as a health and safety or whistleblowing claim, but that could well be how it is phrased later on down the line when the individual hasn't got what they wanted. So always stop, take a measured approach, think about what is actually being said or what could be being said, and then pause and think if any further investigation is needed. And again, with ill health and disability, this applies as well. Any mention of ill health, any mention of potential disability, have a pause. What else do we need to do to understand, to make sure this process is fair and reasonable in all the circumstances? And then it's important to engage the correct procedure and the right team. I put that because many organisations, many of you will have your own whistleblowing teams or whistleblowing processes, health and safety teams, etc. Just making sure that they're engaged in the right thing, in the right way. And likewise engaging those who you need to in relation to medical ill health, occupational health example. So before I close, I just wanted to recap on the practical tips that hopefully have come through this. And I think, to be frank, I could have spoken for hours about this. There is so much here. So it is a bit of a a trot through and recap. But I think any ER case needs planning carefully, but in the COVID context, that planning is just so key. Planning what you're dealing with, why you're dealing with it, and then planning what you're going to do as things come up, having that done at the outset. That will give you the structure to complete a case. And then communicate. This is something that's often forgotten, but making sure that people understand if there is a delay, even if it is only a few days or a week, because your hearing manager is unwell or something and you need to find another one, let people know. Keep people in the loop so they can feel engaged, and this all goes back to that trust point. The best you can, try and get people to come with you on the cliche phrase, but come with you on the journey, because to be honest, once we're in there, it's going to happen. But I think as well, be confident. Don't be tempted to use the long grass that COVID may create for you. It is possible because people are on furlough, or actually it's virtual hearings, or the risk assessment says that I need to take into account someone's mental health. It is tempting, we're all human, to park it or to kick it in the long grass. Don't do that. Or at least don't let the knee jerk and let that be your first reaction. Plan and make sure that any decisions around it are done properly, documented, communicated, so the process can be done as timely as possible to avoid that risk further down the line. And then the final point, because of all these things that are going to be thrown up during COVID, just ensure that you've got the right people for the job. Horses for courses. Ensure that investigation and hearing managers are trained not only in your own ER processes, but in any flex that needs to be done, any adaptions, and make sure they're people who can be compassionate and can do the right thing for the individual. And I think I'm coming close to my allotted time, and Jane's pops up, so I'll refer them back to Jane.
Thanks, Simon, very much. So we've had some questions through on the Q&A function, and in fact the first one follows very much from that final point. So it's, you talked about carrying out these processes when people are on furlough. The question is, can a manager hold a disciplinary, so be a chair of a disciplinary, if they themselves are on furlough?
Yes, thank you. The answer is yes, they can. The ACAS code is clear on that. They're included in that. So somebody can be a chair. Again, it comes back to, are they the right person? Is the circumstances of them being right if they're on furlough? I didn't mention it, but the things to think about if somebody is on furlough is, what are their domestic situations? You know, are they on furlough? Are they the primary child carer, etc.? Have they kind of changed things? All those are the circumstances to think about. But from a legal point of view and a practical point of view, yes, someone can be a chair. It's important to approach them voluntarily to get them on side, which I'm sure you do anyway, because to be frank, you don't want a reluctant chair. That's not going to end well. But yes, you can, but build in all the circumstances in making that decision.
Okay, and then there's another question around people returning to work, and it's an issue that we've discussed a lot in the team. So basically, if a business has carried out its health and safety COVID compliant risk assessment and possibly has gone above and beyond the necessary measures, and they're very confident that they have created a safe work environment, but somebody is refusing to come back because they have a partner who is shielding, where does the business stand from the point of view of disciplining that employee for not fulfilling their contractual obligations?
Yeah, well, again, ultimately, if somebody is refusing to come to work, then it is potentially a disciplinary situation, and that's kind of like the end game. But I think, like with most of these things, you then kind of roll back and say, okay, why is this person not coming to work? And where they're not coming to work because of concerns of shielding, and this is the commuting point maybe that kind of talked about before, you know, bringing risk home. You know, I go to work, and when I come home, I bring risk. A risk assessment should kind of cover all of those, and I think it comes back to that communication point with an individual. Communicate as best you can, or as much as you can, to get them to try and understand their own individual concerns. Why is it different than the risk assessment that's been carried out? Almost like a personal risk assessment for them. And then I think in many ways, actually, it's a bit like reasonable adjustments, in that I think given the context and given that compassion, given the fairness and reasonableness, think about what else can be done. We've already gone over and beyond. That's what our clients are. But is there anything else we can do? And if there really isn't, you're then stuck with the choices are, well, can you furlough the person? Can you put them on unpaid leave until the situation is that they can come back? Do they have leave they could use up? Explore all these options. And if none of those work out, then I think you almost kind of, although I don't like tick box processes, but you've kind of ticked the process to get, okay, well, we don't have any other, there's no alternatives now. We have requested you come back to work. It is safe. Our risk assessment says so. We've explored everything with you. We are in a situation where actually it's disciplinary.
Yeah, okay. So we've got a couple of minutes, just time to slip in a quick one about whistleblowing, which somebody's asked. So the question is, what if an employee has also raised issues with the health and safety executive or HMRC, I guess around the furlough scheme? Is it okay for the employer still to carry on with their own internal process?
Again, the short answer is yes. You can. You just have to tread very carefully, and carefully in terms of making sure that whatever the substance of a whistleblower to HSC or kind of HMRC is, that first of all, people aren't retaliating against that. So you need to kind of put your whistleblowing policy and processes into action to make sure that there is nothing done as a result of that. But if there's an underlying ER case which you need to do, which involves this individual who has taken concerns to a regulator, it's then a process of working out what exactly this ER issue is, if it's a disciplinary or whatever it might be. and kind of hiving that off from the concerns that they've raised with HMRC and HSE. So if you've got a disciplinary and halfway through somebody says, oh, actually, I think what you're doing is wrong in terms of the furlough, and they've raised a whistleblowing concern, pause and stop, hive off that concern, allocate it to the right body. And when that's kind of done, you can then come back and say, yes, but we're still going to look at your own wrongdoing. So very much, but it's that kind of pause and stop. You can indeed carry on. If what you are actually investigating is that whistleblowing issue, then of course it's slightly different. You would liaise with HSC, you'd liaise with HMRC to make sure that they understood kind of what you were doing in terms of your process. Sometimes it may be kind of agreeing that process with them, but you can still run your own process and they'd expect you to in any event. I think it's where there are situations where the police are involved or other things, it may be right to pause, but ultimately you've still got an internal issue that you need to look at, and you need to do that as timely as possible.
Okay, thanks, Simon. So it's 20 to 12 and we said we'd finish after 40 minutes. So I'm going to draw it to a close now and say thank you to Simon for the session and for fielding those questions. Before I close, if you do have time to fill in the feedback questionnaire, which you will receive shortly, please do that. And I very much hope that as many of you as possible can join us for our final and fourth webinar this Thursday, again at 11 o'clock, which will focus on redundancy, again in a COVID context. So thank you very much for listening and watching, and enjoy the rest of your day.
Thank you.